Hi, I'm Clay Phillips. I'm a mediator and mediator trainer, and this video's CLE entitled Mediation and Domestic Violence, the Law and Process is approved for 1 hour of CLE by the Tennessee Commission for Continuing Legal Education and Specialization. Here in Module 1, we'll discuss the purpose and scope of mediation in cases involving domestic violence. One of the main reasons that mediation exists in cases involving domestic violence is one, because there's a lawsuit between two people that either have or have had a domestic relationship. They could be spouses, they could be boyfriend-girlfriend, but the key factors is that they either live together or they currently live together. So that's one of the main qualifiers for the use of mediation in this setting. Next is the courts know that when any of us go to trial and have to go to court for anything, it just increases our anxiety and our stress level. Going to mediation has more times than not the opposite effect, and that is it's because it's private, it's a confidential setting. The people that are involved in the lawsuit aren't exposed to everything else that's going on in the courtroom or the courthouse at that time. Generally speaking, they're alone with the mediator and their attorney, so that by itself also tends to bring the anxiety level down. Next is it's a lot more expeditious of a process than going to court, so it serves the court's docket well in that these individuals or these folks that are involved in this lawsuit don't have to wait to have their issues heard by the court and have whatever it is that they're complaining about against the other person addressed. Next is going to be the matter of safety, just personal safety altogether. In the courtroom, simply because we have court officers and perhaps police officers that are present, doesn't necessarily set up the ideal venue for safety as far as either one of the parties goes, or their lawyers for that matter. At divorce or parenting mediation that involves domestic violence, because it is a private setting, the mediator has a lot more control over where the parties are located and how they are placed in relationship to the other. In other words, in domestic violence mediation, the parties will never see each other. In fact, if they're even in the same building together, they're probably not even going to know what room the other party's in. I've done some mediations, in fact, where one of the parties I had involved using Skype, FaceTime, things like that, just to help ensure the safety of not just the victim that's involved in the case, but myself and any attorneys or advocates that might be involved. Well, in all domestic violence cases, the number one precaution is safety, and one of the best ways to ensure safety is to not have the parties anywhere they can see each other, much less be in the same room together. So the advantage there is not just for the mediator to be able to discuss the issues with each one of the parties openly and freely in a very comfortable environment for them, but also keeps the parties again away from each other, so if one did have an outburst, then at least the other party wouldn't be present when that happened. Generally, the types of cases that are going to be mediated that involve domestic violence are going to have to do with a co-parenting issue. In other words, the people that are involved in the lawsuit are parents of a child. The parents might be divorced, they might be separated, they might still be married, they may never have been married. So generally that's going to be the most common type of case that domestic violence mediation is going to be involved in. There are other types that are not as common, that it might be in fact a civil lawsuit by nature. In other words, it might be a lawsuit that has to do with a business dealing or arrangements that are made in a business dealing, where the two of the individuals at least that are involved in this business dispute had at some time some form of domestic relationship. Something happened, the police were called, a police report was taken, and or one of the parties got an order of protection against the other to keep them at a safe distance, if nothing else, from the other. But those are the types of cases generally that can be mediated using domestic violence mediation, is where there's some sort of criminal activity between the two people that involves person against person, physical violence, sexual violence, typically one of those two areas. When it comes to the types of relationships that are generally involved in domestic violence or domestic abuse cases, generally have no regard for the gender of the parties, sexual orientation of the parties, religious beliefs or preferences of the parties. The main thing is that the two parties have a domestic relationship with one another. Does this mean that this would include roommates? I would tell you that stereotypically, if a police officer is responding to a call, they're going to see this as an assault and then make a determination if domestic violence is also one of the categories of their report. It's not to say that if both parties are male or both parties are female that the officer is not going to see this as a domestic violence episode. If they find out at sometime during the process of taking their police report that the parties are involved in a romantic relationship, it's something more than roommates, the police officer is absolutely going to add the domestic violence element to this. And those types of cases do get treated a little bit differently than, say, an assault between roommates. And the reason being is because when there's what's known as an intimate partner relationship, the different types and levels of abuse tend to go a little bit deeper. They're more pervasive and can put people in a higher level of harm or in harm's way than if it were an assault that did not involve domestic violence or a domestic relationship. The authority to mediate cases involving domestic violence are going to be found both in Tennessee law, and that's going to be generally found in Tennessee Code Annotated 364131, that's the statute number, and also in Tennessee Supreme Court Rule 31, and that's going to be found in Section 17, subsection G, that has to do with domestic violence and the requirements that the mediator must meet to earn the special designation to mediate these types of cases. Now the statute in particular that I mentioned, 364131, provides that there are three requirements that must be met in order for mediation to occur when a case or a lawsuit involves domestic violence between the parties. And that is, one, that the victim or the alleged victim of the abuse cannot be forced to attend mediation. In other words, it has to be voluntary. The judge or the magistrate or whomever the judicial officer is can offer this as an opportunity for the victim to resolve this case rather than have a trial, but that victim cannot be made or forced to attend mediation. Next, the mediator must have special training in mediating these types of disputes that involve domestic violence. And third, the victim is also allowed to have an advocate of their choosing at mediation in addition to an attorney. And that advocate can be anybody from a relative to a pastor or a member of the clergy, a therapist, or their best friend. Whomever that advocate happens to be that they have at mediation, by law is not permitted to charge them anything, and anything monetary to go to mediation with them. the opportunity that this form of mediation offers is that regardless of the level or the type of dispute two people are involved in, they can reach a legally binding agreement as a resolution to whatever that dispute is and avoid going to court sometimes altogether. They can reach an agreement through mediation and then have that agreement filed with the court, and the court accepts it. It becomes then an order of the court, which makes it fully enforceable. So both parties are bound to it, and then avoid going to court and letting the judge decide what the outcome is going to be. If there is any type of physical relationship between the two people that are involved, and something about the relationship turns abusive or even violent to that extent, mediation still can help these two folks avoid going to court, the cost that's associated with going to court, and the stress that's associated with going to court from just having to live with the ordeal and probably even the public humiliation of going to court and being in front of whomever wants to walk in the courtroom and watch. Where mediation's private and confidential, going to court isn't. In order for the case to go to mediation with a domestic violence mediator, one, the law says that there has to be domestic violence in the relationship. And as a mediator, and as well as working with the court, it's my job to help determine exactly what that domestic violence in the relationship or the history might be. The two simplest ways for me to ascertain this, particularly with people I've never met before, I don't know them, is one, is there a police report? Has one of the parties or both of the parties called the police and had a police report taken and alleging domestic abuse, domestic violence, things of that nature? Second, and it might be a situation to where the relationship is completely absent of a police report. Police have never been called. Neither of the parties ever called the police to report domestic violence against the other person or from the other person. But they might have an order of protection. One party might have an order of protection against the other person. In that setting, one of the parties may actually be using the order of protection to, or using it as leverage against the other person to get what they want, when there is, in fact, no history of domestic violence, and sometimes there's not even a threat of harm at all. It's simply a jockey for power or an attempt to leverage against the other party's bargaining ability. If there's an order of protection in place against one of the parties, that can cause a lot of harm to the respondent, the person who the order of protection is against. For one thing, it immediately suspends that person's Second Amendment rights. They can't possess and they can't even be in the presence of a firearm. So if this person, the respondent on an order of protection is a police officer, they lose their job. They can't work at the desk because other police officers are around them and they have weapons. If they're an avid hunter, they can't hunt as long as this order of protection is in effect. If dad is an avid hunter or a police officer, then the respondent, say it's the son, is the respondent on the order of protection, then son cannot go to dad or mother and dad's house for Thanksgiving because dad has guns in the house, because dad's an avid hunter or dad's in law enforcement. That's also to state that the respondent to the order of protection can't even go to Walmart because Walmart sells guns and ammunition. So the respondent to an order of protection is living under a very, very, very intense microscope as long as that order of protection is in effect. And if the respondent ever violates that order of protection, then that becomes a criminal offense, and generally means that that respondent's going to be incarcerated. sometimes and many times, depending on the severity of it and the intent that's behind it, could be all the way up to 11 months and 29 days in the county jail. Well, as sad as it is, or sad as it may seem, there are some people out there that will use that order of protection to leverage either pain or control against the other party. Here in Module 2, we'll discuss the requirements for domestic violence mediation to occur. In order for a domestic violence case to be mediated, first of all, there has to be a domestic relationship between the parties. In other words, they have to be spouses, ex-spouses, boyfriend, girlfriend, girlfriend, any form of domestic relationship. Next, there has to be a history of domestic violence, and that can be either in the form of a police report or an order of protection between the parties. One party has gotten an order of protection against the other party for one of a variety of reasons. Next, the victim or the alleged victim in this lawsuit has to be allowed to attend mediation voluntarily. In other words, they can't be required by the court to attend or participate in mediation. So the judge has to make that determination based on conversations with that victim, and then to determine how beneficial the judge may think mediation is. Next, the mediator must be specially trained in domestic violence issues to be able to mediate these types of cases. What's required of that is the mediator needs to know what the relevant laws are, as well as what the required safety provisions are for the process. And then next, and certainly not least, the alleged victim must be permitted to have an advocate of their choosing at this domestic violence mediation of their choosing. And that can be somebody like their pastor, can be a relative, mother, father, brother, sister, whomever, or a friend, somebody they feel comfortable with that they want to have at mediation for support. Whomever that party happens to be, that extra advocate, is not permitted to charge them anything to be there. There can't be any form of monetary reimbursement or reimbursement for that advocate to be at mediation with them. Just as important as understanding the different individuals that might be at mediation as an advocate for the victim is understanding why that person would be there in the first place. And the sole purpose of the advocate to the victim at mediation is to provide moral support for them. In other words, to help them stay calm, to think more about the issues that have to be addressed and mediated that day at mediation, rather than whatever it is about the relationship that turned violent, that ended up with the police being called, or the victim getting an order of protection against the other party. Now, some examples of who that advocate might be is going to, more times than not, if not entirely, going to be somebody that is immediately involved in the victim's life. And that can be anybody from a relative, for example, the victim's mother, father, brother, sister, could be a brother-in-law, sister-in-law, could also be a close friend or a coworker, somebody that they relate to, again, that is going to provide more of a calming effect for them, that they feel a little more secure during the process. This can also be a therapist. It might be somebody that the victim is very familiar with, as could be a social worker, could be a marriage and family therapist, could be a licensed professional counselor, or it might be a faith-based counselor. And then the next most common advocate that I've seen to come to these types of mediations that involve domestic violence is going to be somebody that's a member of the clergy. Might be their pastor, priest, rabbi, might even be their Sunday school teacher, just somebody they know from church, wherever they find some sort of peace or calm in their life that they can have come to mediation with them. So it can be a variety of people, but the main thing is, again, is why they're there, and that person, that particular advocate, has that close and calming relationship for the victim. Last thing we want to happen at mediation is for the party to bring an advocate that's only going to excite them or incite something that doesn't need to be incited. So those are the things that we focus on. One is somebody that's close to them, that they trust, and that person also is going to have a calming effect on them to help reduce their anxiety so they can get the most out of the mediation process. It's very common for the victim in a domestic violence mediation case to have an advocate with them. In fact, I encourage it when I speak to the victim before mediation, almost assuming that they want to bring somebody with them. And instead of asking them if they're planning to bring somebody with them, I ask them who they're going to bring with them in addition to their attorney. And usually they have somebody in mind, and I just ask them to tell me about that person. You know, what's the relationship like? How do they feel when they're with this person normally? Just to gauge, you know, to see if they have the right sort of relationship with that person, considering that we are going to have them at mediation. So it's very common. Well, if the mediator sets the domestic violence mediation up properly, the other party, or the respondent, or the alleged abuser in the case, is not going to have any idea who's there at mediation. Unless, of course, the other party, the alleged victim in the case, has in one way or another let that person know, that the alleged abuser or the respondent know that they're bringing somebody to mediation with them. They may be using that as leverage just to antagonize the other party. But from the mediator standpoint, I'm going to bring the parties in separately. I'm going to keep them away from each other, so that really the only thing they're left to do at that point is to assume that the other party is only at mediation with their attorney or by themselves. In any case where the defendant, the alleged abuser, or the respondent tries to bring an advocate to mediation with them other than the attorney, the mediator still has the final say. And sometimes it very well may be that the defendant's advocate can actually contribute something to mediation and the parties getting to an agreement sooner. That's not always the case, though, but it's the mediator's duty to investigate that. Ask the defendant, who is this person, what is your relationship with them, and what do you believe that they're going to contribute to us getting an agreement today. And if the mediator is not satisfied that the defendant's advocate or whomever they invite to mediation over and above their attorney isn't going to contribute anything to mediation, then the mediator shouldn't let them in, because that can make situations even worse. And one more person is even that much harder for the mediator to control, both from a process standpoint and a safety standpoint. If you're at mediation and one of the parties, the victim, for example, because they're entitled to have an advocate at mediation, but that advocate begins to either speak on behalf of the party or the victim of domestic violence, or even the defendant or the accused or alleged abuser, the mediator, you know, for lack of better words, has just got to shut that down. Perhaps that would be something that the mediator would want to do before mediation even began, is to have a private conversation with that advocate and explain to them what's going to happen. They appreciate them being at mediation to provide this moral support for the party, their friend or their relative, but that their role today is to not say anything either when the mediator is in the room or out of the room, just as much as anything to keep the process from being derailed. And sometimes that can happen. As well, it might even incite the other party, that where we have the advocate speaking on behalf of the person they came to support, they might agitate that person to the extent that now the victim doesn't want that person to remain at mediation, and might at that time cause that party to want to terminate mediation, to not continue further. And that's happened, one or two times. I've had limited experience with that, and I attribute that just to how I view the importance of preparedness, of being ready before mediation even starts, and following the process and the rules that I've established years ago that have worked best for the process. And I've found that any time I've had an advocate there, again, it's only been a few times, and that advocate caused a disruption or a distraction during mediation, they were very easy to get to leave, or to persuade to leave, or maybe even sit out in the hall while we finished mediation. I just didn't make a big deal of it, so it didn't become a big deal. They must first be a listed family mediator with the Supreme Court, which means they had to have met all of those requirements. And there are 3 requirements that mediator must have met to be listed as a family mediator. 1, they have to satisfy the educational requirements. Generally speaking, to be a family mediator, under Tennessee Supreme Court Rule 31, the mediator has to have at least a graduate degree or an advanced degree beyond the bachelor's level from an accredited university or college. Accredited meaning that either the U.S. Department of Education recognizes that institute, or one of the many regional accrediting bodies across the United States recognizes that institute and accredits them and their programs. Next, the individual must meet the relevant work experience requirement, and generally that's between 6 and 10 years of practical work experience in the field of conflict resolution. Doesn't necessarily have to be in mediation per se, but it could be in a professional role that involves helping somebody else resolve a conflict in their life. Human resource managers, school teachers, customer service representatives, managers, therapists, and members of the clergy are a good example of that type of professional experience. And then lastly, they have to complete the training requirements of Rule 31 to basically complete this requirement triangle. And that's a 1-week program generally that's going to be comprised either of 40 or 46 hours of training. Once the mediator has satisfied all those 3 requirements, then they have to apply to the Supreme Court through the Alternative Dispute Resolution Commission to be approved and listed to be a family mediator. Once that's been accomplished, then that mediator must attend a program that's a minimum of 12 hours in length that covers all the elements that are required by law for a mediator to be certified and especially trained in these domestic violence issues in order to mediate these cases. Once the mediator has accomplished all these things, then they're considered qualified to mediate domestic violence cases. All we have to rely on is what the law says. And what the law says is that there has to be a history of domestic violence in this relationship between the parties who are disputing over something that doesn't have anything to do with any kind of criminal charge. Usually it's going to be they're getting a divorce and they may need to go to mediation to divide their assets and debts so they can complete their divorce, or they have a child or children together and they have to figure out how they're going to co-parent their child. So we have to base the answer to that question on the history of domestic violence in the relationship is something that the court will accept as proof that domestic violence either existed or exists with the parties. And really the only two ways we can do that is if there's a police report of domestic violence where one of the parties called the police and they responded, and a report was taken, and basically we have the police officer's sworn testimony that they at least have enough information or evidence from that call to believe that there's domestic violence in that relationship. Next is if there happens to be, or has in the past, been an order of protection between the parties, which would suggest that there was or there is cause for physical safety from one party against the other party, or that for some reason that a judge found that there was sufficient reason to issue an order of protection, then that's also considered to be evidence to the mediator that there is a history of domestic violence, which then elevates the requirement of the mediator to have this special training. Beyond that, a police report or an order of protection, I don't know that there's any other way to formally determine if there's a history of domestic violence in the relationship between the parties. Here in Module 3, we'll discuss the mediation process in cases involving domestic violence. The difference between DV mediation and non-DV mediation from the perspective of the mediator is really just the factor of safety and providing safety for the victim, providing safety for the attorneys that are there, and the advocate for the victim that comes to mediation, and especially for the mediator. Okay, and the mediator has to, I believe, address safety from their own personal safety rather than worrying so much about the safety of whoever else is there. If the mediator takes care of themselves, then everybody else should be taken care of also. From the practical standpoint, from a process standpoint, there's no difference. Mediation is mediation. The process does not change one bit. Mediation starts in the same spot, conducts mediation the same way all the way through the process, and ends mediation the same way, which is good news for a lot of mediators that don't know anything about domestic violence mediation. They might be interested in it, is that they're really learning about how to prepare for the mediation, how to ensure that the mediation is safe during the process, and then how to close the mediation once the mediation has finished. In other words, how to make sure that the parties arrive and depart safely. The mediator's main concerns for a domestic violence mediation versus a non-domestic violence mediation are going to be what I like to think of as the external environment. In other words, so that the mediation is properly prepared for. In a non-domestic violence mediation, the mediator more times than not is just going to be concerned with the parties' positions on each one of the issues, how they define the dispute, and what they want to happen. Usually there's not any consideration given to the venue other than where the mediation is going to be held. At this attorney's office, at that attorney's office, or at somewhere like I-Center, a neutral location. In domestic violence mediations, though, the mediator has to be very focused on and concerned with the venue, how the venue is laid out, where the different rooms are in that venue that the mediator can use for the process. Courthouses always make great venues. One, because everybody has to go through a metal detector. Two, there are sworn police officers that at least, if nothing else, can arrest somebody. And then there's usually going to be rooms within the courthouse that are either on opposite sides of the building or even on different floors. And then the armed and sworn police officers that are at the courthouse can also help provide for security and safety by keeping an eye on things. Other than that, when mediation begins, the mediator needs to be concerned with the whereabouts of not just the defendant or the accused offender, but they also need to be concerned with the whereabouts of the other party or the alleged victim in the case, because the mediator never knows what this relationship is all about. The mediator will never know what their buttons are, but they'll always know what their buttons are. They may seek each other out. So the mediator's always got to be on the lookout, pay attention to the door, make sure they're ready in case the door swings open, things like that. Finally, the mediator wants to be concerned with, once mediation's done, whether there's an agreement or not, is how we're going to egress. And my philosophy on that is that I have the alleged victim leave first and give them at least a 15, if not 30-minute lead time before I allow the alleged offender to leave. That way I know they've at least had the opportunity to leave the property, get in their car, and be gone for some time, so that I'm not putting the people in the parking lot at the same time together. Something can happen there. On the front end, I always have the alleged offender arrive first. So I can bring them in, situate them, talk with them a little bit, get to know them, and hopefully, maybe help them dispense of some anxiety, anything that might be bothering them. Basically de-escalate them if they need it. Plus, I know exactly where they are. When the alleged victim arrives, then I will place that person in their own private room in another location in that building. So it is important what the mediator does before, during, and after the mediation that they normally wouldn't be concerned with in a non-domestic violence mediation. Domestic violence mediators are required to meet additional requirements than other Rule 31 mediators. First, they have to be a Rule 31 listed family mediator, which means that they had to comply with the educational requirements, the professional work experience requirement, and then the training requirements. So that mediator has already jumped through several hoops to be qualified as a family mediator, and then they can attend and complete some additional training to become certified as a domestic violence mediator. So beyond that, I can only encourage the domestic violence mediator to learn more about domestic abuse and have a deeper understanding of interpersonal conflict, not designed to make them a mental health professional at all, but to understand how it is that domestic partners or intimate partners can evolve from their original relationship and the attraction that's involved in that relationship to a point to where there's personal violence in that relationship, and what that means as far as the mediator is concerned, what the parties are likely to bring to mediation with them that the mediator needs to be concerned about. We never know as much as we might like to know or like to think we know about somebody else's relationship with another person. And as a mediator, we have to do everything we can to be more and more objective. I like to say there's not just two sides to every story. There's at least two sides to every story. And if the mediator will look at all their cases with that idea in mind, but especially domestic violence cases in mind, there's a lot of accusations going in both directions. One party's accusing the other party of this. The other party's accusing the victim or the alleged victim of different things. Well, this is why that happened. This really didn't happen. So the mediator's got to be ready for those types of things to come up in conversation, and one of the best ways they can is to continue to educate themselves about this different dynamic that they're going to find in these types of relationships. before mediating any case, every mediator should take specific measures to find out if domestic violence has ever occurred or is currently an issue between the two people that are subjects of the lawsuit, one person suing the other person. Because we work as aides to the court to help resolve disputes in lawsuits on that court's docket, we are performing a quasi-judicial function, which just means that everything that we do from start to finish has to be based in honesty and integrity. And a big part of that is the requirement that both parties to the lawsuit, or every party to the lawsuit, feel comfortable and safe with the process. So the mediator's incumbent duty for every type of lawsuit or case that they mediate is to do everything they can to find out if there ever has been any form of domestic violence or domestic abuse between the parties. And the best we can do there is to find out if there's a police report or if there's an order of protection between the parties. Beyond that, there's no database that the average mediator is going to have access to that shows every order of protection that's in effect or ever has been in effect. So the mediator is going to have to do some legwork. They're going to have to make some phone calls, generally to the court clerk's offices, and maybe in areas that they know that the parties have ever been, and also to check the best they can to see if there's any history of police report being made or charges being filed from one party against the other for domestic abuse or domestic violence. And lastly, and one of the things the mediator can do that I've found that a lot of mediators just don't do is ask the parties on your intake when you're talking to these people about what's going on and what is some of the history of this dispute, where did it start and where are you today, is ask them if there's any history of domestic abuse or domestic violence in their relationship. And I've found that at least one of the parties is going to be very forthcoming. And remember too, for the mediator, that this isn't something that either one or both of the parties is going to be very proud of. They're very likely, in fact, going to be ashamed of it. But the mediator has to ask that question. They have to ask the question of the clerk's office. They have to ask the question of any law enforcement agency they may be able to ask with respect to any police reports that might exist. And they have to ask the parties. If they don't, who's going to ask the question for them? A Rule 31 family mediator who is specially trained in domestic violence issues is the only mediator that is permitted to mediate a case, whether it's domestic, juvenile, or civil. And civil meaning anything that isn't domestic or juvenile, everything else that's left. And it matters not at that point what the nature of the lawsuit or the dispute is. For example, if there's a business dispute between two people, say for example they sell cars at the same car dealership, or they may work in the same building, whether they have the same employer or not, it really doesn't matter. But if somehow they have some sort of business relationship that goes south, they may have created a business together and they need to now dissolve the business or get out of it. If at any point there has been any type of domestic relationship between the two parties, romantic relationship, whatever you may want to call it, that existed before, during, or after this civil dispute, this non-domestic, non-juvenile dispute, then the mediator is going to have this specialized training in domestic violence issues. And that is primarily because it's required by law. So in that scenario where you have two people that are in business together, say they dated at some point either before, during, or after this dispute existed, something happened, somebody got mad, maybe one of them did assault the other one, and a police report was taken. Maybe somebody was arrested. Somebody went to jail for this charge. Or there's an order of protection that ever existed between these two people, then the mediator has to be a domestic violence mediator. So the answer is to the question is no. Not just any mediator can mediate a non-domestic, non-juvenile case, which leaves the civil cases, that type of case where there's domestic violence between the two people, whether it's, again, a police report for an incident that's happened in the past, or if there's currently an order of protection between the two, or there ever was an order of protection between the two. The mediator has to be domestic violence certified. Here in Module 4, we'll discuss the key safety elements of every mediation that involves domestic violence issues. The DV mediator, in preparation for mediation, needs to make sure of a few things, and that's to do as much as they can that's within their ability. First of all is they want to find and be familiar with the venue where they're going to have the mediation. Simply because if they're going to be safe, they're going to conduct a safe mediation, then they're going to have to know how to get in and out of the building pretty easily. And when we talk about safety at mediation, we have to think about safety for the mediator first. That has to be our first goal of safety. Obviously, if the mediator's not safe, they can't do anything to help anybody else be safe. So we have to be very familiar with the venue. It can be someone's office, it can be a public building, something like that, but considering that domestic violence is an issue, it's always a really good idea to make a courthouse the first consideration. And that's because, one, there's metal detectors, two, there's security that's on site every second that the facility's open to the public, and the majority of those are sworn law enforcement officers. So if somebody needs to be taken into custody, they can, and that doesn't create another issue should something like that happen. So they want to be sure that they've done their due diligence to make sure that they are very familiar with as much of any history of domestic violence between the parties as they can. They absolutely have to know if there's an order of protection between the parties, because one thing that the mediator doesn't want to do or have happen at any time is to cause an order of protection to be violated. So we have to ask the questions. We have to ask the parties. We have to ask their attorneys. We have to ask the clerk's office about histories of domestic violence or orders of protection. Because if we don't, who's going to ask it for us? So the mediator has to take responsibility for that way before mediation even occurs. The next thing that the mediator needs to do before mediation is to be ready, is to make sure that they understand the issues as to what the parties are actually mediating. And understanding that they're not mediating anything that has to do with any domestic violence or abuse that's within the relationship. That's not what's being mediated. What's being mediated might be that the parties are getting a divorce and they need to decide who's going to get the house or how the house is going to be disposed of. Who's going to keep this car and who's going to be responsible for paying for that car. Other things too that are just as important, if not more important, is where are their children or their child going to live the majority of their time? How much time is each parent going to have with each child? What does that schedule look like so that that can be very predictable? Well, these issues have nothing to do with the matter of domestic violence in the relationship. So again, what the mediator wants to do before mediation is to, one, make sure they're very familiar with the venue, make sure that they know who the security personnel are that are on site in case they need to use their services. Hopefully they won't, but they need to know who the security personnel are that's on site. They also need to inquire as to any histories of domestic violence or orders of protection with the attorneys, the clerk's office, and the parties. And if it comes to the mediator's attention that there is a history of domestic violence or there is an order of protection, then the mediator needs to immediately contact the judge in that case for the issues that are about to be mediated and let them know they're going to be mediating the case and that they're specially trained in domestic violence issues, and be available if the judge wants to ask them anything in particular about the process. How do you go about making sure that this victim is going to be safe according to the law? And the mediator has to be ready to answer those questions. Then finally, the mediator just needs to be prepared altogether like they would for any mediation. And that is what the dispute is about, what are the issues central to the dispute, and what each one of the parties' position is on each one of these. So then the mediator can arrive at mediation and perform all of their functions pretty carefully, as well as without much consideration, so that they know they're going to be safe, they know the party's going to be safe, and they know they're going to cover all the issues that need to be mediated that day. In order to make sure that the DV mediation venue is safe, the mediator needs to become familiar with the facility. Whether it's a public building, whether it's an attorney's office, or a courthouse, the mediator has to have an intimate knowledge of that facility, meaning the mediator needs to know where every door into the building is and where every possible exit route is out of that building. The mediator also then needs to use this information so they can plan their own egress should anything arise, especially in an emergency situation, so they can get out and get to safety as fast as they can. Because the best opportunity to keep a victim safe at mediation is for the mediator to be safe during the entire process. Other things that the mediator needs to know about the DV mediation venue is going to be who's in charge of the facility, and if there is any on-site security, and if there isn't on-site security, if the building management has any issues with the mediator bringing their own security with them, which is highly recommended if it's not in a courthouse, is to hire an off-duty police officer, sheriff's deputy, somebody like that has arresting authority to provide security for them. If they're in a courthouse, all the previous rules apply. They need to be very familiar with the building. They need to be very aware of how somebody can get in and get out of the building, especially for their own safety, so they can get out of the building very safely and very quickly. And then know the role of anybody that is on site at the facility that is in charge of security. At a courthouse, there's going to be one person that's in charge of physical security of the venue. Mediator needs to know that person, get to know that person, find out how they do business, how they go about securing the facility, and then the mediator has to be able to communicate what their needs are for this DV mediation to that security supervisor or the facility manager. Other than that, if there are multiple security personnel on site, the mediator would be very wise to at least make an introduction to each one of these people, tell them who they are, what they're doing, why they're there, and where they're going to be. And just extend that professional courtesy so that the security personnel are not curious. They have no reason to be curious about who the mediator is when they see them walk out of one of the rooms. Also, that the security personnel, all of them, supervisors and all the other officers that are there, can inform the mediator of any irregular behavior of either one of the parties that they may see. For example, the mediator may be in the room with one of the parties, and the security officers or officer sees the other party leave their room and go outside to purportedly smoke a cigarette or something like that, and then come back in the building. Just to let the mediator know that, hey, they left, they went outside, I don't know where they went, or I do know where they went because I watched them. Just so the mediator understands what's going on and has as big of a picture of the party's activities as possible. And the facility security personnel are the best people to help them with that. So on that note, the mediator, again, is very wise to develop a relationship and a rapport with all the security personnel on hand. Now, it's also important to note that ensuring the safety of the victim of the mediation is not something that's just going to happen, one. Two, it's no one's responsibility except the mediator's responsibility. In order to make sure that the victim of domestic violence stays safe at mediation, the DV mediator needs to first of all, have a plan for the arrival and the departure of both the parties to and from mediation. What I like to do and what I recommend is that the mediator have the alleged offender or the abuser arrive first. Always start with them, get them in. You know, I would say shoot for 30 minutes prior to the start of mediation and get them situated. And in particular, if we're at a courthouse and we're doing this mediation, that gives the mediator time to talk to security personnel after they've met the alleged abuser and has a chance to kind of gauge their personality and the mood that they're in, let them know what's going on, and then have the victim, the alleged victim, arrive again 30 minutes later, get them situated, and then tell the alleged victim what's going to happen at mediation. And if the mediator hasn't already begun the process with the abuser, the alleged abuser, then the mediator should start with the abuser first. And that, again, is designed to mitigate any stress or anxiety that the abuser may have. Also could come across as a sign of goodwill from the mediator to the abuser. The mediator also then needs to be sure that they really monitor and gauge their time, how much time they spend with each party. It needs to be very balanced, not any more balanced than it would be at any other mediation, but the mediator should absolutely pay particular attention to the time they spend with each party. One way that I manage that is I record that in the time in, the time out in my mediator notes. And so I can go back at any time, review those notes, and not just see how much time I spent with the parties, but in relation to how long we've been here at this mediation, how long ago that might be, so that I can keep in mind that they might need not just breaks, but we might need to order lunch. Somebody might be getting hungry. So a lot of this that the mediator's managing is about both the victim's experience as well as the abuser's experience at mediation, to not do anything to agitate or excite their state of mind at that time. They're already going to be in a certain place in their mind, in some form of crisis, and the mediator just doesn't want to agitate that at all. Other than that, the mediator wants to be sure that the parties understand that neither of them are going to be forced into anything, that their best opportunity as far as this situation is concerned is at mediation, for them to stay in control, stay in charge, make all the decisions, and to not allow the judge to make those decisions for them, especially when it comes to raising their child or children, is the mediator should always encourage the parties to take advantage of mediation, because if it doesn't work in mediation, then the judge is going to, essentially tell them how to raise their children. And that this is the opportunity that they should take advantage of so that they're making those decisions instead of the judge. All of this, again, going back to the mediator being very aware of and mindful of what the experience is for each one of the parties, and not assume that only the abuser or the alleged abuser is the only one between these two parties that's excitable or has the potential or propensity for violence. The mediator needs to make sure that they treat both of them equally and with the same amount of caution and care. Now, in the event that the offender finds out, or somehow discovers that they are being required to arrive 30 minutes prior to the victim, and say, for example, they take exception to that. In other words, why do I have to be here 30 minutes earlier? What's going on? What's this all about? Some may tend to feel like they're being trapped or entrapped. The mediator needs to be ready to explain to the offender or the alleged offender that that's just part of this process, because there is a history of domestic violence. There are certain things about the process that the mediator must adhere to, and that is to keep the parties apart and to begin mediation promptly. So it's not just that the offender is arriving 30 minutes prior to the victim, but it's that the mediator is starting mediation promptly when the offender arrives and gets situated in the room. The mediator is going to be required to give both the offender and the victim an orientation session or an introduction describing to the parties who the mediator is, and what their role is that day, what everybody's role is, the parties and their attorneys, how the process works, and what the ground rules are. The mediator has to do that with both parties. Shouldn't take any more than 5 minutes to accomplish that. And because the offender is already there, then the mediator can, right after giving them the introduction or the orientation session, should go ahead and start mediation and ask the offender, or that party in particular, the beginning questions. Why are we here, and what do you hope to see happen at the end of this mediation today?